Good morning. My name is Patrick DeRay, Chief of the Bureau of Automotive Repair, and I want to welcome everyone to a public workshop involving a draft regulation package that we have developed at the Bureau of Automotive Repair in response to legislation that was chaptered last year, AB 471, bill introduced by Assembly Member Lowe, who at that time was chair of the Assembly Business and Professions Committee. That bill was signed into law by the governor and took effect on January 1 of this year and has a number of provisions to requiring the Bureau to implement various provisions of that bill. One of which is the purpose of today's workshop, regulations to establish a remedial training program for automotive repair dealers in anticipation of another package that we're working on involving citations for violations of the Automotive Repair Act and associated regulations. This workshop also will cover certification of remedial training providers, those who are providing that citation training. And we have a fairly brief presentation that we want to share with everyone before we open it up to questions and answers and some comments from the public. Before I get much further along in today's presentation, I want to thank our host, David Booley from the Department of Consumer Affairs. He will be our moderator for today's event. Also want to thank our co-moderator, Zach Richardson, who is here in the bar executive office. And any questions, they'll monitor those throughout the duration of the meeting today. Can everybody hear me fine? David, I'll have you respond on behalf as the moderators. Is my voice coming in loud and clear?
Loud and clear.
Good. As I said, this package is one of just a number of packages that we'll be working on in response to the chaptered legislation, AB 471, and workshops that we've kicked off the year in January with a public workshop following our last bar advisory group meeting in late January, dealing with the citations program that already mentioned. So this is kind of coming on very quickly on the heels of that public workshop, and I anticipate many other workshops to follow dealing with the various provisions of that bill. So I want to welcome everyone today to this particular workshop involving the remedial training aspects of the bill. Trying to think, that should do it. It looks like we have about 20 some odd attendees, 23 to be exact. So thank you all who are here. Let's turn it over to Matthew Gibson, who is a program manager 2 on an assignment to work on all things relating to this bill, AB 471. That was my first order of business after the bill was chaptered, was to create a single point of contact for all things relating to this bill, and many of which are, many of the aspects of this bill require regulation development. Matthew has an extensive background in the field operations and enforcement branch of the Bureau's enforcement division, and more recently in the last few years has come to work for us in our centralized case management office here in Rancho Cordova at the Bureau's headquarters. So when we created this position on a limited term assignment, we had the vision that someone from the enforcement division, because of the many aspects of the bill that deal with enforcement related aspects of the Bureau's mission, that someone from that division would be the successful candidate. And after going through the competitive hiring process, Matthew was indeed selected to be the person for this job. So welcome, Matthew, and we are ready to turn it over to you for the presentation on this draft regulatory package that I might say before you get into the presentation has been fairly extensively reviewed by folks here in the Bureau, but also those that we need to have our regulations reviewed by at the Department of Consumer Affairs, most notably our Legal Affairs Office has already had a chance to take a look at it, and some of the provisions that you've seen are in light of some of the very excellent feedback we received from our legal counsel. So, Matthew, your turn.
Thank you, Pat. And again, I'm Matthew Gibson. I'm a program manager in BAR's executive office. And I'm here to discuss the proposed remedial training for automotive repair dealers and provider certification regulations. This is the first workshop for these proposed regulations, but the regulations for the remedial training and provider certification that we'll be discussing today are only the second of 3 regulation packages that I am working diligently to get in place for implementation of a new citation program for Automotive Repair Act violations. The first of those 3 packages, and Pat was referring to it, is the citation program for automotive repair dealers, which we held workshops for in April and July of last year, and after the Bureau Advisory Group meeting in January. The third of those 3 regulation packages for automotive repair dealer registration application requirements is currently in development, and we're hoping to have a workshop on those proposed regulations after the Bureau Advisory Group in April. All 3 of these regulation packages need to be in place by July 1st of 2023 to meet the statutory timeline for implementation of the new citation program for Automotive Repair Act violations as envisioned in Assembly Bill 471 by Assemblymember Lowe. Since the proposed regulation text is 8 pages, I have put together this PowerPoint, which contains 7 slides to cover items contained within the proposed regulation text. I should say that obviously this is a rough draft, which is intended to solicit input. We do anticipate that there will be changes based upon our discussion today, as well as internal discussions at DCA and at BAR. So, the proposed regulation text will create Article 12.5 in the California Code of Regulations for remedial, so remedial training for automotive repair dealers and course provider certification. The proposed regulation includes an application process to obtain a provider certification, a remedial training course content and course approval process, and grounds for revocation of a provider certification. Under the proposed 3395.6, those wanting to provide remedial training on BAR's laws and regulations as a result of an ARD citation or a disciplinary order must obtain a provider certification. Those applying for a provider certification must submit a completed application, possess an active state bar of California license, be qualified to teach the course content, and disclose any prior criminal convictions or disciplinary actions. There are 2 things I want to point out about 3395.6. The first is that the provider certification is needed not only for the remedial training to prevent disclosure of a citation, but also for laws and regulations training ordered as a term of probation by an administrative law judge in a disciplinary order. The second is that I would imagine that is clear by saying that a provider must possess an active state bar of California license, that we want attorneys to be providing this training. We believe that BAR would be best served by having attorneys providing this training, because this class is about the interpretation and application of the laws and regulations that make up the Automotive Repair Act, and attorneys are trained and licensed to interpret and apply the law. Also, attorneys' licenses are overseen by the State Bar of California, which we believe will make our oversight of this program stronger. And we expect that attorneys will bring a level of professionalism, which we believe will help to ensure the integrity of this program and guard against some of the concerns that can arise in remedial type training. So the remedial training course shall, at a minimum, consist of instruction on the following areas. So we have estimate requirements, customer authorization, invoice requirements, accepted trade standards, sublet repairs, advertising requirements, guarantees and warranties. I'd like to point out that those are just the minimum subject areas to be covered. Additional subject areas could be covered as well. And the minimum content for the remedial training class is identical to an optional training course contained within our proposed disciplinary guidelines for administrative law judges to consider as part of a disciplinary order with probation. The remedial training course shall be a minimum of 8 hours of instruction and examination. There will be a bar-specific post-course examination to verify student knowledge obtained from the instruction. Students must obtain a minimum score of 70% on the post-course examination to receive a certificate of completion. A certified provider may not provide remedial training without a bar-approved course. In order to obtain bar approval for a remedial training course, a certified provider shall provide the Bureau with a course outline and description for review. And approved courses will be valid for 2 years from the date of bar approval. And two things I want to point out about this slide. The first is that only a certified provider can submit a remedial training course for review and approval by bar. And the second is that the 2-year expiration is to ensure that the training is up to date with current laws and regulations. If after 2 years there hasn't been any changes to the laws and regulations, then a provider can resubmit the previously approved training to bar to be approved again. Section 3395.8 states a provider can be revoked for any of the following reasons: a disciplinary action against the certified provider's state bar of California license, failing to comply with provisions in section 3395.7, failure to accurately document student attendance, providing false, inaccurate, or incomplete information to students or bar, and conduct constituting fraud. And that is the conclusion of the PowerPoint presentation. So we would be ready for questions. If Zach's going to take it over as far as the co-host role.
This is the moderator. Could we please have the questions slide? Thank you. So we're now open for public comment. If you would like to make a comment, please type the word comment in the Q&A box in the lower right-hand corner of your screen and send that comment to all participants. If you're a dial-in user, please dial *3 to raise your hand. We'll call on people in the order that we have requests for comments.
Thank you, David.
We have a request for comment from Jack Moldenoff. Hold on just a moment, please, and we will send you a request to unmute your microphone. All right, Jack, we've sent you a request to unmute your microphone.
Hi, this is Jack Moldenoff. Can you hear me?
Coming
Yes.
in loud and clear. Go ahead, please.
Okay, thank you. I wanted to thank Matt for the presentation. Good job. Also say that agree with many of the provisions in this regulation. I think it's consistent with AB 471. I happen to be a lawyer. I agree with the provisions requiring lawyers to teach laws and regulations. Also, the curriculum laid out in terms of the standards are what I think, again, AB 471 envisioned. My question is in terms of the timing, because you've got 3 packages here, Matt. You've got the citation package, you've got this package, and I know how sometimes regulations, you submit them and sometimes they get held back. In terms of the timing, is this going to be the first one or the last one, or in terms of the timing? Can you talk a little bit about that?
I mean, I could try. All I would say is that if I thought about the sequencing, they all kind of, the 3 that I was talking about in the introduction, as far as citations for automotive repair dealers, this remedial training one, and also the ARD application, they all kind of have to hit at the same time. I need them in place by July 1st. Actually, probably a little bit before that, so we could start accepting applications for remedial training providers. I would say that the remedial training regulations and the provider certification could probably, of the three, probably should go first. One, because of we need to accept applications or to certify providers, but we also need it independent of the citation program because of the disciplinary guidelines and the fact that that course exists, and we needed to establish who was going to be providing the training. But fundamentally, I need them all at the same time, as soon as possible.
So is it possible that this package gets approved? I mean, in terms of approved before the July 2023 date? I mean, is there, if everything goes well and you have you've done all your work, is there any reason why you couldn't hold the formal hearing and then also just after that to submit to the Office of Administrative Law and not wait for the other two that may end up having some more issues to deal with? Can this be submitted beforehand? Or they have to be all submitted at the same time?
I don't know that they need to. They all kind of are they're all interconnected, but this one, I mean, theoretically could go, but
They don't have to, all three packages do not have to go over as one comprehensive package. They'll be submitted when they're ready to be submitted. And presumably this will be the first one in the line or in the queue to go over to the Office of Administrative Law after we complete our internal review process.
Right.
And then notice it for the 45-day public comment period. But this could be in place, as Matt said, as the first package. If adopted, it would be ready in advance of July 1, as Matt said, to begin accepting applications from those seeking certification as a remedial training provider. That is the first piece of this. So this package does logically seem to need to go first and doesn't need to wait for the other two.
Okay. Yeah, that was my question. Thank you. Thank you, Matt. Thank you, Pat.
All right, next we have a request for comment from Gilbert Rios. As a reminder, you only need to type the word comment into the Q&A box in order to get called upon. Gilbert, bear with us just a moment and we will send you a request to unmute your microphone. All right, Gilbert, we've sent you a request to unmute your microphone. All right, Gilbert, we're going to send you another request to unmute your microphone. All right, Gilbert, we're going to circle back to you in just a moment. Just for the moment, Gilbert wrote, would a bar certified school have the opportunity to teach the class? And
I'm sorry, was there more to the question? I didn't mean to interrupt.
that's the entire question.
Oh, well, a bar certified school could teach the class if they had a bar certified provider.
All right, and Gilbert has notified us that he does not have a mic.
Well, I hope then I was successful in answering his question.
Yeah, I'll just elaborate a little bit on that response. The only bar certified institutions or schools are for the smog check, more technical training of the smog check program. And there are bar certified instructors as well under that program. We're not envisioning the same type of certification approach as with the smog check program. In fact, the draft regulations are somewhat different in that we're only certifying the instructor, the provider, not necessarily the institution. So, for example, if for some reason a smog check institution that provides smog check training wanted to somehow expand the scope of their training to more broader applications beyond the smog check program to the Automotive Repair Act, which is in the Business and Professions Code and entirely outside well, not entirely, but for the most part, let's say, outside the scope of the health and safety aspects of the health and safety code aspects of the smog check program, certainly could do so, but they didn't need to be. We're not looking at whether they are certified, the school that is, but rather if they have a certified training provider.
And thank you, Pat. And that's right. It's an individual certification. And I kind of laid out the requirements, specifically that they're going to have a state bar of California license. So if a school, and it doesn't have to be a certified school for smog check, it could be
Sure.
Yeah, it could be a
Yeah.
community college. I mean, for that matter, anybody who wants to, if they want to put this class on, they need a certified provider who we'd have to, well, that we certify based on the requirements.
Excellent point. Thank you.
All right, next on the list we have Robert Ayers. Bear with us just a moment and we'll send you a request to unmute your microphone. All right, Robert, we've sent you a request to unmute your microphone. All right, Robert, we're going to send you a second request to unmute your microphone, and I'm going to take this opportunity to read what you've written. Robert says, this is obviously to comply with bar regulations. What about the fact that most complaints are caused by bad workmanship by the technician, i.e., it isn't fixed? How are you addressing the bad technician problem? They can go shop to shop and cause the shop to receive complaints. No shop owner training will address this issue.
I think that more speaks to a question relating to the regulation package that was workshopped in January. Matt, maybe you could touch upon, I know it's kind of outside the scope, but it's related, of this regulatory package. Maybe touch upon what we're envisioning for compliance with that citation, the citation training, and any violations that are found and are the subject of that citation issued by the Bureau.
Well, yeah, we do obviously have the first of the 3 regulation packages that we've been working on for the citation program for automotive repair dealers. And the sections that we were envisioning related to workmanship, specifically about the accepted trade standard violations. Those are one of the ones we had talked about, making sure we were focusing on trying to issue citations out for trade standard violations, which has to do with the workmanship issue I believe you're addressing in the question. Accepted trade standards is also a part of the remedial training program as far as one of the required areas to be taught. As far as us addressing bad technicians, I don't know how to address it other than to say that we want to make sure that the people who we register to be repair shops understand the responsibilities to be their shops have to be in compliance with, as far as estimate invoicing requirements, accepted trade standards, and estimate invoice, accepted trade standards, and that they can hold their technicians accountable for those regulations.
There was a provision in one of the regulation packages that spoke to training beyond the owner.
Oh, okay.
That's what I was getting at.
Yeah, actually, it hasn't been written in. We had talked about it related to this package, but it's not currently in the text. And the idea was that remedial training could be, we've set the standard that the person has to attend. Oh, okay. The provision you're talking about was in the citation for automotive repair dealers is actually 339455, I believe. It talks about the person who would have to attend remedial training in order to prevent disclosure of an ARD citation. And that person would have to be listed upon the application, the automotive repair dealer application. So somebody who is an owner or a partner or a corporate officer, but also anybody who is a responsible person that's in charge, indirectly or indirectly in control of the business, who would be listed upon the application. Those are the people we're targeting to ensure that we get the training to the people who we regulate. But in addition to that, we were going to, and we intend to include language about the idea that that training should also be attended by those that were directly involved in the violation for which the citation was issued.
That's exactly what I was getting at.
Yeah, I apologize. I got it now.
All right. And Robert said that he was unable to unmute. Robert, would you please type in the the Q&A section if you need more ability to speak? We'll pull up some text slides in a minute for you. If your question is answered, let us know that too. Let's move on to Chris Cleveland. Bear with us just a moment, and we'll send you a request to unmute your microphone. All right, Chris, we've sent you a request to unmute your microphone.
You guys hear me?
Yes.
Yes, go ahead,
Okay,
please.
perfect. Thank you. Well, thank you for allowing me to speak. My comments are really related to section 33957.7B on the standards for approval of remedial training courses. And I kind of have,
I apologize, Chris, I didn't mean to interrupt. Do you want us to pull up the text?
I don't think it's necessary.
Okay.
But just under that section, which is the standards for approval, I had kind of three different comments.
Okay.
Number one was I would suggest adding a provision or further clarifying that the certified provider should demonstrate how they'll ensure that any certification of completion will be protected against fraud, forgery, and other verification, just to ensure that whoever these certified providers are have a mechanism of verifying that it wasn't forged or fraudulently completed somehow. And I think we've seen that problem in other types of courses out there where somebody can either cheat the system, generate a fake certificate of completion. I think there should be some standard that the BAR looks at for approving providers and making sure they've accounted for that. One mechanism may be through something like a blockchain certified digital certificate. My second comment is, given today's environment with what seems to be constant and regular cybersecurity breaches, in fact, I think it was just announced today that the California State Bar believes that there was a data breach on tons of different court records in California that was caused by one of their contract management vendors. And so it just seems like this is constantly in the news. So that's just a coincidental example of a state agency. But I think, there's also the California Consumer Privacy Act that was enacted recently. And there's obviously going to be a lot of information in here, potentially sensitive information, employee data for the ARD, what their citations are, things like that. And I think the provider should have to, if they're hosting any of the system in a cloud-based software, that BAR should be ensuring that they are compliant with, and reasonably protected against a data breach. Because you could have, any company out there, putting with not secure password policies, no encryption, right? And that would be dangerous and also be a reputational threat to the credibility of the whole program. And so I think that vendor or the certified provider should be able to, show and demonstrate that they are protected reasonably against a data breach, maybe even adopting the California Attorney General or Department of Justice's guidance on complying with what they call the Center for Internet Security Controls. That was what Kamala Harris back in 2016 said that businesses should conform to. So that might be a way to do it, is kind of piggyback off of what the AG and DOJ recommended in their 2016 data breach report, which to my knowledge is still the current standard in California. So that was number two. And then finally, I had a suggestion that there should be more specifics about the provider demonstrating, again, that trainees will not be able to skip through or cheat the system, again, preventing this from becoming similar to an online driving school type of situation where it can easily be skipped through, or where people don't actually have to read any of the content, just get to the end of the course, press finish, right? I think there should be specifics about BAR vetting out these providers to prevent that from happening.
Okay. Thank you for your comments, Chris.
All right, and next, Johan Gallo said disregard. He had the same question. Think we understand what you're asking, that you want us to disregard, but nevertheless, we're going to give you the opportunity to unmute and speak just in case there's something more to say. All right, Johan, we've given you a couple of opportunities to unmute, and that appears to be the last of our comments and questions. We're going to check one more time. Oh, we have a raised hand from Wen. Bear with us just a moment, and we will send you a request to unmute your microphone. We see. Good morning. Go ahead, please.
Sure. Again, my name is Hao Win. So just want to get that a little bit, straighten that a little bit. But thank you again for your time this morning. Really appreciate it. And I just wanted to reinforce and support the idea that an attorney needs to be present for as a provider. Not as you may know, attorneys in California not only have to take the bar exam, which consists of 3 days of examination under 14 subjects of the law. We need to take courses called CLEs or continuing legal education to maintain our licenses. So I think that's more of an objective standard that reinforces the integrity of what bar is trying to do in the program itself. Not necessarily a question, just a comment. Thank you.
And I appreciate it. Thank you.
All right. My apologies on the mispronunciation of your name. Do we have any other requests for comment or questions? Looks like we have another request from Chris Cleveland. We've sent you a request to unmute your microphone.
Yeah, I just wanted to add one more thing. I think also for the standards, I would suggest another requirement that the provider demonstrate the ability to prevent questions from being published online. I know with driving school, for example, that's been a constant problem with the DMV is, these online courses, somebody out there, especially in today's world of social media, will take the course once, just post all the answer choices online, and anybody can just find that and then, pass the quiz or the test, right, for the 70%. So I think that should be a huge concern in the regulations of, again, making sure that the provider is able to adequately prevent or protect against that. Maybe, for example, like a question bank that has to be updated on a monthly or quarterly or annual basis or something to that effect, so that you prevent courses from, because there'll be an incentive for some of these providers to just create a program, never touch it again, and charge for it, right? So you want to make sure they're actually forced or required to update that question bank, prevent that test from just being released online. I think that would be important.
Well, let me follow. Thank you for the comment, but let me just follow up. The way the regulations are currently drafted, the examination at the completion of the course is supposed to be a bar administered examination, although internally we're figuring out how best to achieve that. What are you suggesting? I wouldn't be expecting to get questions from a provider. I guess that's what I'm trying to say. Is your comment, given that information, are you trying to say something other than, like, do you believe that the provider is the ones that should be doing the post-course examination?
Yeah, I mean, I would think that the provider should be doing that. I think it's going to be a better way for the BAR to kind of distribute the resources. And, I mean, rather than the BAR having to take on this entire liability and, kind of time-consuming task of becoming a test administering agency, which today is not the case. I think it would be better suited, especially given the requirement that it's going to be licensed attorneys. Licensed attorneys are very well positioned, and you guys are well positioned to outsource that to attorneys who can come up with those questions, keep it updated on a regular basis, and it'd probably be better overall for the program if it was kind of relied upon on these outside companies to do that. You'd probably get a larger question bank, keep the questions more accurate and updated. You can rely on the expertise of some of these, people who have real life experience, working at ARDs or at dealerships. And that kind of brings me to another point too, is I second, I think, what one of the other commenters said about, the person who attends the training, it should be somebody who caused the violation. And, I came from a dealership background where, this may not be the case for like a smaller repair shop, but like at a dealership, especially a large, maybe, large dealership group, the person, who could take that, the owner or maybe even the shop manager, is not really involved in the day to day. And if that person were to take the training and they were the ones to satisfy the requirement, I don't think that we've accomplished consumer protection in that case, because, the owner of the shop may be completely a passive owner who doesn't even come in, to the dealership. Or it may be a service manager who doesn't even have anything to do with, he may be overseeing 100 technicians and 100 advisors, and training him doesn't really accomplish anything. So I definitely think, and second the comments, that should be somebody, the person who completes the training should have been involved or caused or contributed to the citation.
Thank you for that comment too. And I think that was very similar to the question we got from Mr. Ayers.
Right.
But I was going to say that it's kind of the same situation. We are all for as many people as taking this training as possible, even in advance of, I mean, just so that they make sure that their businesses are operating in compliance with the laws and regulations. It's proactive is not a bad thing. Having said that, we have control over the registrations that we issue and the people who those registrations are issued to. And I can say that they need to take the training because they're the ones who are responsible for that registration. Once we get down to the levels of the business for people who are not registered or licensed with BAR, it becomes more complicated, and we can make suggestions or recommendations that they should also attend the training if in fact their conduct was the cause of the violation. But that's kind of where our ability at that point to control who's attending it ends.
Yeah, and without knowing how the regulatory process works, like one suggestion might be in the language to say that that shop owner, whoever that person is who owns the license, is required to, enroll also anyone who was involved in the citation, and it then becomes their responsibility to enroll those people in the training.
Okay.
I think that's, thank you, Chris. That's a good comment and something we were envisioning. Short of a fairly comprehensive licensing program to license all auto repair technicians in the state, which has been debated for a number of years on whether that's a good thing or a bad thing, or the Bureau takes no position on it, but it has not been something the legislature has acted upon, short of anything requiring licensure of all technicians. The best I think we can do is something along the lines of what you were talking about, and what we already envisioned for that other regulation package dealing with the citation program and who would be subject to the remedial training.
And I should point out also that this regulation package for the training provider and the course content, again, it's not just about the non-disclosure of a citation. It's also about disciplinary orders and people who are on probation. I mean, once somebody's on probation, they're going to be ordered to take this training, so we can totally control that situation, or as much as we can, right? But the point I'm making is we have focused ourselves on the remedial training when in fact it's not just that. It's also disciplinary actions and probationary requirements.
All right, this is the moderator. We do not appear to have any additional requests for comments or questions. How would you like to proceed?
I'll maybe give one last call out for any final questions or comments, and if none, we will adjourn.
All right, sounds great. Last call for questions and comments. Please type the word comment into the Q&A box in the lower right-hand corner of your screen, or dial *3 to raise your hand. We'll call on people in the order that we have requests for comment. All right, we're going to give it about 15 more seconds. All right, I believe this concludes questions and comments.
All right, thank you very much, everyone who attended the workshop today, and for your participation and feedback on this draft package. As far as next steps are concerned, we'll have to take a look at the comments we received and see if additional changes are necessary to the package. Some changes might be forthcoming. I'm not sure that will warrant another regulatory workshop or public workshop on this draft regulation. We'll have to take a look at that and see how substantive the changes are, and do we want feedback on that? We might even just send an rather than workshop, maybe just an updated a notification to review an updated draft on our website, and feel free to comment, but there will be, when we file these regulations with the Office of Administrative Law, that will give another more formal opportunity to respond to the draft regulations, whatever version that is, if there are changes. So you'll have an opportunity, even if we forego another workshop on this matter. As Matt said, we're kind of on a tight timeline to get these regulations adopted by next July 2023. I know that seems a long ways away, and we don't even have our vacation plans or anything like that planned for next year. But there's a lot of work that goes into getting a regulation adopted. So July 2023 is an ambitious timeline for us. But that's what was set in statute in AB 471, the bill that was chaptered last year, and we will do everything possible to meet that. So anyway, we'll take a look at the comments and see how extensive any changes might be that we might need additional feedback on, and whether or not it warrants another workshop before we finalize the regulations and send for the more formal public comment process through the Office of Administrative Law. So having shared those next steps with you, I think I want to thank once again our moderators, David Booley and Zach Richardson, for hosting the meeting and taking everything in from the standpoint of the comments that we've received today, and filtering those for both Matt and myself to respond to. We're ready to adjourn. I thank you all again for your participation and attendance today. Thank you.
All right.